appeal in the matter of D and K are children.
Yes, Mr. Turner. Now, before you embark, we've got a great deal to get through. We've got sorry, I can't see some of you because of that lamp. Only a limited time to do it. So I think it might be helpful for all of you if I'm able to tell you that we have each done a great deal of reading.
Great.
So we've of course read the judgments and the skeleton arguments and a number of the statements and dipped extensively into the authorities. So I hope that will be of assistance to all of you. We've got the... My Lord Justice Moylan sent me a very helpful note, if only if I'd been able to read his writing. He is reminding me to remind you about the anonymity.
To do what, sorry?
As the anonymity of
yes.
To ensure that none of the children are identified in this.
Because we're live streamed.
We are live streamed. I have got a button that I can press, and if the worst comes to the worst, we can make amends later. But if people could try very hard to avoid naming any of the children, I would be very grateful. We have your timetable. Thank you.
Right. There are conjoined appeals before the court, and each of those appeals involves 3 parties, all separately represented, and there are also 2 entities which have been permitted to intervene in both cases.
Yes. And
each of those entities is separately represented. I mean, happily, not everyone is present here in court today. Some are watching on the live link until their turn comes tomorrow to speak. Would the court like me to formally introduce the cast of thousands?
No, I don't think so. We don't really want to only embark on submissions at lunchtime.
Yes. Mr. Bennett has provided, I hope, a schedule.
Yes, we have.
Of
we have, thank you.
Council, and indeed a schedule that we've agreed of timetable.
Yes, that's very helpful. Thank you very much.
That's appropriate.
And so, as I understand, just so that I'm clear, I think it's counsel for the interveners who are observing on the live link.
It is indeed.
And apart from that, I think we've got everyone else that's on our schedule.
Yes.
Excellent, thank you.
Lady, in the appeal in which I appear, I represent the subject child,
yes,
who is the appellant. I say child, but whenever I say child, can you replace it with young person, please? Because he is really a young person. He's 13 and a half years old, and everyone seems to think he's reasonably mature from the reports that are in the papers. And I lead Mr. Edward Bennett, who has in turn been assisted by Miss Natasha Miller, who acts on a pro bono basis, assisting Mr. Bennett. Mr. Bennett, of course, was counsel for the child at the hearing below, and he, together with Mr. Richard Harrison, KC, settled the grounds of appeal and the skeleton argument. So I'm very much the new boy in the case. Just to avoid confusion, our effective skeleton is in the core bundle at tab 4, page 24, and our perfected grounds of appeal are at page 43. It's a little bit confusing because tab 1 says appellant's notes and grounds of appeal, and then tab 2 appellant's skeleton argument. The second skeleton argument was the one in support of a stay.
Yes.
So you need to look at tab 4, which starts off with the skeleton argument, which stands as the skeleton today, and that's immediately followed by the perfected grounds of appeal, which are slightly different, in particular in that there are 3 grounds rather than 2 grounds as appeared originally. Can I, before I go any further, apologise if I appear to be a bit robotic, but I've done something to my neck and I can't turn my head very easily. It's going to make it difficult for me to dodge any bullets that are coming from the court. Mother was represented below by Mr. Michael Edwards, and he's here today led by Mr. Michael Gratian, King's Counsel, and the mother opposes the appeal. The father was a litigant in person below, he is here today. He's represented by Mr. Jason Green, and it's changed. It was Professor Rob George, and it's now Ms. Fazila Ismail, and they are appearing pro bono, as I understand it. The father supports the child's appeal, but it's right to note, and for me to emphasise, that the father's conduct was criticised heavily below by both of the other parties, by those who represent the child and those who represent the mother, and indeed by the judge. But having said that the father's conduct is to be criticised, as everyone has done, we are anxious for that not to deflect the focus from the subject child. Because the subject child, we contend, has his own separate perspective that must be carefully assessed and put in the balance. And that arises in particular in the context of the question of the influencing of the child by the father in relation to his objections. Because there are three possibilities there, we submit. One is that the father brought malign influence to bear, and that was successful, and the child is simply parroting the father's views. The second alternative is that the child took them with a pinch of salt, as Mr. Netto described it at one stage, being well used to the parents on both sides behaving, as we would suggest, inappropriately. The third possibility, and one which is important not to overlook in my submission, is that the child was influenced and that the father's influence formed the background to the child's objections, but that doesn't mean that the child does not now hold those objections and hold them strongly and hold them genuinely and hold them authentically. When bearing in mind, it's not a question of how we got to where we are and moral blameworthiness, but of what the child's actual position is in terms of objections. If he has strong objections that are now genuine, however he came to acquire those objections, whatever influences came to bear on him, he has them. And that, therefore, is something that should heavily be weighed in the balance when exercising the discretion under the child's objections, as I shall call it, exception. And that's one of the things that we suggest that the judge didn't do below. But both of the appeals before the court include points as to the proper role of a solicitor who has been appointed as a guardian to represent the interests of the subject child in proceedings under the 1980 Hague Convention, in circumstances where the child has been joined as a party. Because, as we now know, but which wasn't appreciated until the judgment some time ago of Mr. Justice Baker, as he then was, when a child is joined as a party in Hague Convention proceedings, he must have a guardian. The guardian can be a CAFCAS officer, it can be the official solicitor, or it can be any other person, in fact. And we'll be looking at the rules where we find that. There are some fairly complex points that arise in that regard, and in particular, there's an issue as to the extent to which, if at all, evidence may or should be given by a solicitor guardian. That's evidence of any sort. Because there are those who contend that a solicitor guardian should not be giving any evidence. And there is further a point as to, even if a solicitor guardian it's permissible for the solicitor guardian to give evidence, is it permissible for the solicitor guardian to give opinion evidence? Now, in the present case, we'll see from paragraph 43 of the approved note of judgment. Can I check the court received yesterday the approved note of judgment, because the only one that's in the bundle is the unapproved version.
Is the approved version substantially different, Mr. Turner?
I don't think so. I haven't checked them word for word, and I didn't get them in track change form.
No,
I haven't compared them.
It's just that I don't know. For my part, I've been working for the unapproved version and had duly marked it up.
Yeah.
So the paragraph numbers.
I think the paragraph, they should be the same. If paragraph 43 starts, I turn to the court's analysis of all of this.
No, that's 42. Almost inevitable.
One of the problems that we face in this appeal is that even now there is no proper transcript of the judgment below. Although there is a note of judgment, an agreed note of judgment that went in the bundle, and the judge himself has now, as it were, made some changes to that and approved it. We only got the approved version, I think, yesterday.
Is that in the bundle or is it loose?
No, it's not. It's been sent by Mr. Netto, I think, to the court as a separate item, so it's not in the bundle. So, I mean, that's one of the problems we now face. Not only do we not have a transcript of the judgment, we now have two different versions of the note of the judgment.
Well, how would you like us to deal with it? Have you got any?
I'm not going to refer a great deal to the actual judgment, to particular paragraphs.
As we only seem to be one paragraph out, shall we muddle along and no
Yes,
doubt
and if
the
I say,
juniors
well, the
can-
paragraph
can-
starts with these words,
Yes.
it's around
yes,
there.
and no doubt the juniors will help us if there's any substantial.
But it is a
change.
second best only having even an approved note of judgment.
Mr. Turner, we are very conscious of the difficulties that there are with
Especially for
obtaining
those who
transcripts.
come into the case from scratch, as it were.
And it's a
But
problem
even
across
more
the board.
problematic, I suggest, is the absence of a transcript of the oral evidence that was given before the court. Evidence from the Kafkas officer and evidence from Mr. Netto, the solicitor guardian. All that we know about such evidence is what appears in the note of judgment. But there may be some quite nuanced points that could be taken in relation to that evidence. I've certainly not seen it. I wasn't present at the hearing, so I don't have any personal knowledge. Now, that doesn't affect any issue of principle, but it may be relevant to issues as to the way in which the case was determined on the particular facts. And what is annoying is that transcripts were bespoken promptly. They were chased continuously. It wasn't until the end of last week that Mr. Netto was at last told the tapes, the audio tapes or the recordings had been sent to the transcribers, and then yesterday he heard the wrong tapes had been sent to the transcribers.
Well, my heartfelt sympathies to Mr. Netto for such a frustrating and fruitless task, but it's no justification, but it is a problem that is we're finding not just in this appeal, not just in family appeals, but across the piece, Mr. Turner.
Yes.
And our lawyers do their very best to support the solicitors who are trying to obtain the transcripts, but we're at a state now where an expedited transcript is taking upwards of a fortnight.
And furthermore, though it doesn't create a problem, we don't even have a sealed copy of the order from below.
We have a very full note of the judgment that's been agreed and
Yeah,
approved.
as I say,
So-
the judgment isn't such a problem. The fact that there's no sealed order is not a problem at all.
No.
The absence of a note of the oral evidence may be a problem, but it's all
Mr.
symptomatic of the...
Mr. Turner, with respect, you know, Counsel for Perfection would obviously have been to have a transcript of the oral evidence, but you and I both know that so often we obtain those at great expense and considerable effort on the part of solicitors, and if they're referred to at all in the appeal, it's only passingly. So I think, given the vast amount of information we've got in relation to this case and the very full note of judgment, that your lay client and the child are not in remotely prejudiced by the absence.
I do ask it to be borne in mind.
Well,
of course,
I really don't think it's going to make any difference.
Of course, my submission ultimately is going to be is that there should be a rehearing of this case. It's my submission the judge didn't take on board the fuller picture in relation to the child, but I'll come to that obviously. But in what's paragraph 43 of the approved note of judgment, which I think your Lordship says is 42 in
Yes, I turn to the court's
previous
analysis.
notes. I turn to the court's analysis of all this. In his two statements, Mr. Netto provided two distinct types of view. First, the views of the child. Second, Mr. Netto's own views about the views of the child. It is accepted that the first category is completely admissible. But nevertheless, that question does seem to have been raised, certainly by some of the interveners, as to whether solicitor guardians should be giving evidence at all in such cases. Indeed, in the present case, there was actually, as we'll see, a positive direction for the solicitor guardian to provide a further witness statement after his first witness statement had been prepared in order to support the application for the child to be joined, and dealt with things such as competence. And curiously as well, in the solicitor has to give opinion evidence as to competence, and nobody seems concerned about that. But if the solicitor guardian, the child having then been joined, made a party, and having had that same solicitor appointed as solicitor guardian, gives opinion evidence, then there is then criticism of that, or at least there is now criticism of that. Although for years, rightly or wrongly, the giving of opinion evidence by solicitor guardians in these sort of cases has become a relatively common practice. I think we're all familiar with many cases where it's happened without demur, without any objection being raised whatsoever. And we can demonstrate that from not only the anecdotal evidence, but from the reported authorities that are in the bundle. And as we go along through some of them, I'll point out ones where there has been opinion evidence from a solicitor guardian for which the court was grateful. I mean, not critical, but positively grateful, including one case in front of Mr. Justice Cobb where Mr. Netto's views found favour with the court. I'm going to confine myself to the position in Hague Convention cases, although solicitor guardians do give evidence, I know, in other types of children law cases. And certainly I've seen cases where the opinion of a solicitor guardian has been preferred to the opinion of a CAFCAS officer or a NIAS guardian. Whatever the position may be in law as to the giving of opinion evidence by a solicitor guardian, what we contend is that in the present case, the trial judge in effect stifled the voice of the child because his stance towards, one, the giving of opinion evidence by the solicitor guardian, and two, because of the importance he placed on the father's attempts to influence the child, distracted him from investigating properly the true strength, the true factual, actual strength of the child's objections to a return to the overseas country from which he'd been wrongfully retained. And the judge thus failed to weigh in the balance what may in fact be that true strength and rationality. And he did that because he in effect discounted Mr. Neto's evidence about it, albeit, as I shall submit, there's actually very little that's inconsistent, if anything at all, that's inconsistent between Mr. Neto's evidence and the Kafkas officer's evidence. It's just that Mr. Neto gives a more full view. As the Kafkas officer, I think, had accepted at one point in her evidence, the child seems to have opened up more to Mr. Neto and formed a rapport with him, and he spent more time with the child. It's a much more detailed report. And even if one strips away the opinion evidence from Mr. Neto's evidence, one is still left with his recitation of the child's wishes and feelings as expressed to him, which again produces a much more forceful objection than that recorded by the Kafkas officer. But that's all been discounted by the judge because we say, number one, diverted by this question about whether Mr. Neto should be giving opinion evidence at all, and secondly, because of this question of the father's influence, without stopping to ask, well, yes, the father may have brought influence to bear, but what's the consequence of that? Does the child actually genuinely have these objections now, whatever the origin of them may have been? It's the genuineness of the child's objections which we submit is meant by the word authenticity that appears in lots of the cases. So we say if you just look at the purely factual evidence that Mr. Neto gave us, the wishes and feelings of the child, when stripped away from the opinion evidence, that factual evidence wasn't inconsistent with the evidence of the Kafkas officer. And that factual account of the child's wishes and feelings itself bore out the opinions that Mr. Neto then expressed. And I'll take you to some law later on that suggests that anyone, not just a solicitor guardian, anyone is entitled to give opinion evidence on matters relating to their factual evidence. Of course, rather trite to say, but of course, parents in children cases give opinion evidence all the time. Oh, I thought he seemed a bit sickly on that day, or whatever. I mean, one can think of many examples. Of course, there's that fine line as well between what's fact and what's opinion. And what was it, the old aphorism about the state of a man's digestion and...
So your submission is it's not expert opinion evidence. It's just evidence of a person's opinions.
It's a person's opinion.
Yeah.
It comes from a person...
It's factual evidence of
yes.
their opinion of
yes.
the
yes.
nature of the child's views, objections.
Yes. I don't hold Mr. Neto out, and he doesn't hold himself out as an expert in the sense that you would need a Part 25 application to adduce the evidence, but he has a certain expertise because he wouldn't have been appointed the solicitor guardian if he didn't. A judge is required to consider carefully who the solicitor guardian is and what qualifications, experience they have, that sort of thing, again, as we'll see. So he has a certain expertise, and within that expertise, he was providing an opinion which is therefore relevant to be put fully into the balance, not just discounted, as in reality Mr. Neto's opinion was, and that had the knock-on effect, as I say, of distracting from even the wishes and feelings evidence that Mr. Neto provided, which the judge says nobody complained about. And it seems to have been common ground between the Kafkas officer and the solicitor guardian that despite the father's disgraceful attempts to influence the child certainly wasn't parroting the views of the father. And I come back again to that question about, well, whether the child had been influenced by them or not is the consequence that they are now the child's genuinely held strong views. Because if you discount them because they've been influenced by the father, then that's incorrect in my submission. The undisputed background to the present case in just a paragraph, really, if I may, and then I'd like to go through a little bit of the history of it because it's quite important as to how things came about. There's been years of litigation overseas between the mother and the father about the child, about just about everything else by the look of it. It shouldn't be overlooked that there had at one time been shared care overseas. The father came to live in England. He wanted to have the child here as well, but the overseas court refused permission for that. There was then a period of no direct contact between the father and child, but eventually the father obtained permission from the overseas court to have the child in England for a holiday period. But at the end of that period, the child wasn't returned. That's the simple background. It was an absolutely classic and egregious case of wrongful retention. And the provisions of the 1980 Hague Convention would require an order for return forthwith to the overseas country unless the case could be brought within one of the exceptions provided for by Articles 12 and 13 of the Convention. The father relied on various of those exceptions, but his case in relation to all of them was rejected by the trial judge. The child had become a party to the proceedings in circumstances in which I'll go into a bit more in a moment. He, through his lawyers, didn't support the father's case in respect of those various exceptions, but he promoted his own case of what I'll call colloquially child's objections under Article 13. And I probably don't need to take the court to that, but you can find the actual wording in Authorities Bundle at page 6. It was accepted by the judge that there was an objection within the relevant principles as a matter of fact. That gave rise to a discretion as to whether or not to make an order for a return forthwith. And it's the exercise of that discretion that is what we're concerned with in this case, and what was taken into account and what was, we say wrongly, discounted. Of course, discretion doesn't mean the judge can just flip a coin and say, well, this is what I'm going to do. It's got to be a judicially exercised discretion, like all discretions, and some of the factors that are taken into account, and again, one can find them in the authorities that are cited in the judgment, but the strength of the objections, importantly, the authenticity of the objections. I've already said that my submission is authenticity actually means genuineness, not just had it been influenced. And like all such discretions, as I say, it can look at the whole picture, it can look at general welfare considerations, and it can look at policy considerations. But when looking at policy considerations, again, the authorities show one shouldn't be stuck in the headlights of you've got to return at all costs to discourage others. You've got the individual child. And the exception, if it's been made out, which it has in this case, albeit the discretion hadn't been, the exceptions are all welfare driven themselves. So you would to some extent be acting against the child's welfare if you return him despite his objection. Can I just say, in support of my argument about authenticity and genuineness, one can draw an analogy with a case decided by Mr. Justice Peter Jackson that's in the bundle, S&S. It wasn't a child abduction case, it was a relocation case. It's, I mean, if one wants to look at it, it is, it's in the bundle at tab 27. And in that case, and I won't go through these in detail because I suspect the court's not going to be giving judgment straight away after this, and we'll want to look more carefully at some of these authorities. But it's a case on relocation that had to be decided on the principle of welfare, and it was again a case where a father had behaved disgracefully, and he'd been seeking an order to relocate the children to Switzerland. And he had brought such enormous pressure to bear that the children were categoric that they wanted to go to Switzerland and wouldn't be content if they didn't go to Switzerland. And although the father and his influence was castigated by Mr. Justice Peter Jackson, and the father was ordered to pay the costs, the judge felt that one nevertheless had to look at what the effect was of the improper influence. It wasn't just a matter of the children parroting the father's views, they genuinely had them ingrained into their psyche that they couldn't bring themselves to return.
So basically you said if the children's views were as a result of brainwashing,
Yeah.
then that counted.
That can count because if you...
That then becomes their so-called authentic views, despite the fact that they're brainwashed.
Because it affects the child's welfare. Of course, you can put that in the scale against other things, but I do commend that authority to...
Could you just take me to the paragraphs in the judgment that says that?
Hold on, let me open up the...
I don't think they're sidelined. I hope that's...
No,
Well,
they're
none
not.
of the authorities sidelined.
And what was also criticised in that case was that there had been a surreptitious instruction of solicitor on behalf of the children. I can't take your ladyship to, as a member, to a particular paragraph. I'll ask those behind me to have a look while I'm speaking. But paragraph 22, children's wishes and feelings. I don't say that the way in which the wishes and feelings or the objections have come into existence are irrelevant. But I do say that one has to look very carefully at the strength of those wishes and feelings and objections and the consequence of, or the potential consequence of not going along with them, and asking whether they're genuine. And another question is whether they are rational. Because in this case, we submit that the child's objections, as reported by Mr. Netto, were rational. Strength not fully investigated because of the discounting of proper evidence. Rational, albeit possibly come about as a result of the father's influence, although Mr. Netto's opinion was that the child was well able to bear in mind the significance of that influence the father brought to bear. Hadn't been brainwashed in that sense. If one looks at the child, says, well, I know this is what my father wants, I know my mother wants something different, they've been arguing this for years and years, it's always the same, I've had enough of it, and I know this is what my father wants, and I know he goes on and on at me about it, but it's what I want to bring all this to an end. And a perfectly rational reason for it. But again, it's a question of proper investigation of this. I'm not saying that this court can say, oh, well, that would tip the balance. What I'm seeking is a retrial when all of this can be properly investigated, if it's relevant, and not just discounted on the basis, well, the father, first of all, the father must have influenced him to, says the judge. I reject the idea that it wasn't the result of influence. And once the influence is established, then that's pretty much it. Other parts of the background of the case may not be quite so apparent. Importantly, I ask the court to note that it was before any 1980 Hague Convention proceedings were commenced by the mother that the solicitor, Mr. Netto, who is a well-known practitioner in these sort of cases, indeed he is, or certainly was, the chair of the Child Abduction Lawyers Association, and has been spoken of approvingly in various cases.
Well, we could spare his blushes, I think. The judge made it perfectly clear, and I repeat, for the benefit of the record, the judge was very careful to emphasise the respect and integrity and honesty
I'm sure Mr. Netto is very grateful.
So I think we can spare his blushes.
But it goes a little bit further than that, because it goes to the level of Mr. Netto's expertise. And even though he's not an expert in the sense that a Kafkas officer is an expert, he does have an expertise in dealing with these sort of cases and children. Now, he was consulted before there were ever any 1980 Hague Convention proceedings. Because one of the complaints that's made is, oh, well, people go off like in S&S, where the father went off and consulted someone surreptitiously, and that person was acting surreptitiously on behalf of the children until it all came out. But this, it seems here that the father had himself been consulting counsel, I think this is openly known, with the result that he was provided, the father, with solicitors who regularly act for children. So, of course, the instruction of Mr. Netto was driven by the father.
So the father arranged for the child to see Mr. Netto
Yes.
prior to...
But of course, there are various routes by which solicitors come to represent children. We know in the other conjoined appeal here, it was the school who sent the child to see him. There are many and various routes, but the trouble is, you can't criticise someone just for saying, well, the child has a view. How is he going to get a solicitor? How does that happen otherwise? But in any event, the child was put in touch with Mr. Netto at the instigation of the father, I accept, and instructions were taken from the child in detail by Mr. Netto, not from the father, and that resulted in Mr. Netto sending to both the father and the mother the letter that's in the supplemental bundle at page 133. And the supplemental bundle, to make it clear, is what was the trial bundle. And so he made it perfectly apparent that he'd seen the child. There was no underhand lack of transparency.
Sorry, what page?
133 in our supplemental bundle.
Sorry, I misheard.
133. I mean, just to summarise, what he does at the end of that letter is invites the parents separately to confirm they'll be willing to engage in mediation with an independent third party. So a sensible step, you may think. But what it does demonstrate is there was no lack of transparency on Mr. Netto's part. And it was only subsequently that the mother's application under the 1980 Hague Convention was issued. And knowing of Mr. Netto's involvement with the child, the mother's solicitors then gave notice to Mr. Netto of the first directions hearing. So that's how he came to actually be involved in the 1980 proceedings. He was given notice of the first hearing.
Sorry, I'm just looking at the chronology that's in the bundle at page 7. So, 17th of December last year, the child travelled to the UK. And on the 6th of January, the father sent the mother a message saying that the boy had decided to stay in this country. That was the 6th. The 9th, the police report was lodged in the country abroad. Then on the 10th, the mother applied to the central authority, so that was before this letter.
She may have applied, but the proceedings didn't start in England.
But on the 11th, there was a welfare check conducted. So the father was well aware by the 11th of January that the mother was taking...
It wouldn't take too much intelligence to guess that sooner or later Hague Convention proceedings would be started.
I thought you were implying that really, the mother had been a bit slow, and it was only in response to the letter from.
Oh no,
Netto
I'm sorry
But if the reality is that it's quite clear that the father took the child to see Mr. Netto when he was perfectly well aware that already things were in progress
Well, I don't think
as a
Mr.
result
Netto
of his
knew that there...
wrongful retention. I'm not saying Mr. Netto. Mr. Turner, can I just say again, nobody thinks for a moment that Mr. Netto behaved with the other than with the utmost integrity.
Well, it would have been obvious to anyone who practices in the field that unless some form of agreement was reached, there were likely to be 1980 Hague Convention proceedings. Mr. Netto, before any such proceedings were issued in England, sent that letter inviting the parties to consider mediation. The proceedings were then started in England. Because the mother's lawyers knew that Mr. Netto had been instructed by the child, they served Mr. Netto with notice of the hearing. And Mr. Netto went along to the hearing on behalf of the child with Mr. Bennett as counsel, and he applied for the child to be made a party and to have himself appointed the solicitor guardian. And as the rules require, in support of that application for the child to be joined and for himself to be made a solicitor guardian, he filed a witness statement. And that witness statement is in the core bundle at page 125.
Do you want us to turn that up?
Sorry?
Do you want us to turn that up?
If you could just turn up, because there are a couple of points I'd invite the court just to flag up, as it were. And the first point I make is in paragraph 2 on page 125. Mr. Netto expresses an opinion as to competence to instruct. Nobody's ever complained about that. And indeed, the Law Society guidance in such cases assumes that there will be opinion evidence of that sort. And he expressed an opinion as to the desirability of joinder. Effectively, he was saying the child has a perspective that's different from either of the parents. The father can't put forward the child's case without it being said, oh, well, this is your case really. And the mother is unlikely to be putting forward the child's case unless it agrees with hers. So the child has a separate perspective that needed to be represented. And that's one of the circumstances in which a child will be joined as a party.
I mean, you could say that about every child abductions case, but it's not every child abductions case in which a child is joined as a party. What's considered to be the leading authority on joining a child to 1980 convention proceedings? Is there one?
Well, I suppose one goes back to the old House of Lords Raid D.
Mm. Well, that just set out the options.
That just sets out the options.
And said, if I recollect correctly, that it would be rare that a child would need full representation.
And then there's the rules. What is it? Let me.
But there's
Can I come back to that? Because I will flag that up when I come to it, because there is a rule that deals with that gives examples of the situations in which a child should be joined as a party.
And if we're looking at if we are, I'm saying if, we don't have to, but if we're looking at the broader issues, when consideration should be given to joining a child, and what evidence or information the court should have before making that decision.
But again, both of those 2 points are points I'm going to cover.
Good.
But in a nutshell, it should be as soon as possible, at the first hearing, if possible, and there should be evidence in support of the application. That I'll point you to the actual rules and authorities that deal with that. But dealing with Mr. because I'm telling you what happened, and
Yes.
then we'll look to
Yes.
see how that complied with the rules. So, Mr. Netto, in paragraph 3, sets out a short CV in order to assist the court in deciding whether he's an appropriate person within the requirements of the rules. And the stage at which that application was made accorded, I submit, with the most recent version of the President's guidance, which is in the authorities bundle at tab 26. Sorry, tab 36. That's page 702. Electronic. And if we look at paragraph 3.6, which is at page 709, and this is the latest version of the President's guidance. Paragraph 3.6. The issue of the participation of the child, and this is all to do with child abduction, the issue of the participation of the child must be considered at the first hearing, where it is clear on the face of the application and supporting evidence it will be appropriate for the child to be heard during the proceedings. The court may give a direction to facilitate this at a without notice hearing. Well, this wasn't a without notice, this was an on notice hearing. Where directions have not already been given, the question of whether the child is to be given an opportunity to be heard in proceedings having regard to his age and degree of maturity, and if so, how, must be considered and determined at the first on-noticed hearing. The methods by which a child may be heard during the proceedings comprise a report from the officer of CAFCAS High Court team, or through party status with legal representation. In most cases where it's appropriate for the child to be given an opportunity to be heard in proceedings, an interview of the child by an officer of the CAFCAS High Court team will be sufficient, etc., etc. And that's really taken from Lady Hale's speech in Ray D.
And it goes on as my Lord Justice Moylan points out, in only a very few cases will party status
It's been necessary, yes. And we'll look in a moment at the examples of situations where it may be necessary. I invite attention also to paragraph 3.14, oral evidence. Three lines up from the bottom, any party seeking to run oral evidence should raise the issue at the earliest available opportunity and no later than the pre-hearing review. Of course, we're not at the pre-hearing review yet, we're at the initial directions hearing, but bear that in mind when we've got the document open, when we come to the pre-trial review. And if we look at, for example, tab 14.
Tab 14.
Tab 14 of the authorities.
No, can I ask at lunchtime if I've got an exploding pile?
Oh, it always happens,
well,
doesn't it?
It's nobody's fault it happens,
Sorry.
but I'd be very grateful if someone could dig out a new one and...
That's the one advantage of using an iPad, I suppose.
Steady on.
Until it stops working.
Tab 14.
Tab 14, it's a well-known Ray M and others. It's the Irish case dealing with comprehensively with the law on child's objections by Lady Justice Black, as she was. and you only have to look at the head note rather than necessarily look at the actual substance of it. At page 248, head note number 2, that in proceedings under the Hague Convention, it was imperative that consideration be given at the earliest possible stage to whether the appropriate parties were before the court, which meant considering the position of the children who were the subject of the application, including one who was a child for the purposes of the procedural rules, although no longer within the scope of the convention, because we had in that case a child who himself was 16 or more, so wasn't subject to the convention. And the court then went on to do with what happened if the application for joinder was only made in the Court of Appeal for the first time, when the CPR rather than the FPR applies. So we're not really concerned with that. But we'll see in a moment that Baroness Hale in Re D had said at the first opportunity.
Well, yes, because the proceedings need to be determined expeditiously, but on the other hand, the parties in the court need to have sufficient information to make a reasoned decision. And as we all know, typically in a Hague Convention application, the first statement affidavit is usually quite terse, just setting out the background and setting out the overarching contentions. So there isn't a great deal of information available to the court to make as I say, a reasoned decision as to whether or not it is appropriate for a child to be joined.
I understand that. I understand that in some cases a court may say we haven't got enough information, but I'll explain in a moment just how it came about that the court did make a decision at that first hearing in the present case, because it did make a decision. But before I do that, can I turn back to Mr. Neto's witness statement? In paragraph 4, he gave an explanation as to how he'd come to be instructed. So his involvement in the court proceedings flowed from notice being served by the mother, and that witness statement, made in support of joinder of the child and in support of Mr. Neto himself being appointed solicitor guardian, contains all sorts of information, including opinion evidence. For example, in paragraph 8, just before the quotation, I could sense that Jay became slightly more withdrawn. I was left with a firm impression that he was quite simply fed up of his parents fighting. Of course, that's an opinion. It doesn't purport to be an expert opinion, but it's a practical, common sense opinion. In paragraph 29, Mr. Neto, for the assistance of the court, refers to the relevant case law. So nobody can say the court that this came before wasn't aware of the case law. And the very first case he refers to in paragraph 29 is the Ciccone case, where Mr. Justice MacDonald had expressed the views which are quoted in the judgment in our case about whether a solicitor guardian should be giving evidence, even if appointed, in preference to a CAFCAS officer or as well as a CAFCAS officer. Because our case is that best of both worlds have both. The solicitor guardian being permitted to give evidence, including opinion evidence, and the CAFCAS officer. And then the judge can weigh it all up. It can all be cross-examined. If you start off on the basis, well, the solicitor shouldn't be giving evidence, you're not from the starting point. You're approaching it with a closed mind, as it were. And paragraph 32 8, page 133, at no point was I left with the impression the child was parroting his father's narrative. Paragraph 35, 5th line down, above anything he struck me quite frankly as being fed up. The first hearing took place on the 22nd of February this year before Deputy High Court Judge Bowen, King's Counsel, and the court was made aware by the mother's then counsel of the material showing the father's attempts to manipulate the child. You haven't got it in the bundle, but there is a position statement that had been filed on behalf of the mother making that clear. And the mother, as my Lord says, hadn't filed her lengthy witness statement by then, but the court was made aware that such material existed. So the court which was making the decisions on the 22nd of February wasn't deprived of that information. It was nevertheless the mother's case that it was premature to join the child, despite, as I submit the authority, it says it should be done at the first opportunity. And it was her case that there should be a Kafkas report which would be more objective. And in that regard, reference was made to the Ciccone case. So the judge wasn't deprived of information about relevant points. And as I understand it, the matter was before the court for the greater part of the day on the 22nd of February, where the judge heard submissions, read material, and retired to consider the arguments and the authorities which were provided for him. The order that was in the event made is in the supplemental bundle at page 110. You see, if you turn over to page 111, paragraphs 14 and 15, after that consideration, it wasn't just a superficial consideration on that day. The child was joined, paragraph 14, and Mr. Netto was appointed the child's guardian, paragraph 15. And then paragraph 20, a positive direction for Mr. Netto to file and serve a witness statement. That's in addition to the one he'd already served in support of the application for joinder by 4 p.m. on Wednesday, the 3rd of May. Previous paragraphs are dealing with witness statements to be served by others. And then in paragraph 28, a Kafkas report to be prepared to address the issues set out in that. There is no indication as to what it's expected that the further witness statement of Mr. Netto should include. But you will have seen from the skeleton argument on our side, the reference to the authority, the Child Abduction Authority, Mr. Justice Cobb, where it's made clear that there had been opinion evidence from Mr. Netto, which was accepted. That's the authorities. I needn't take you to it. But in the authorities bundle, if you look at that authority, the paragraphs are paragraph 42 at page 516 of the bundle and paragraph 57 at page 521. And I say that, sorry,
Tab?
the tab of the
24 maybe.
Thank you.
34, grateful.
24. 20.
And I say that simply as a demonstration of how these things have been done to date. I don't say it's because they've always been done like that, that's right. But I do point out that is what's happened. That's what's become the practice. And the Kafkas report was duly filed, dated the 11th of April. I needn't take you through in detail, it's in the core bundle at page 153. Starts at page 153 and it's tab 15 in the core bundle. Paragraph 24, page 160, I do not believe that the child had been provided with a set narrative. He freely answered the questions without hesitation. He was balanced within his views about his life in England and the overseas country, as well as his relationships with his mother and father. However, his decision to remain in England was a direct result from the conversations he'd had with his father, as stated by the child himself. Paragraph 26, throughout my interview with the child, whilst the conversation flowed naturally, at times it became stilted. The Kafkas officer had a much shorter involvement with the child than Mr. Netto did, and as she accepted in cross-examining her oral evidence, the child does seem to have opened up more to Mr. Netto and formed a rapport with him. So his evidence as to the child's wishes and feelings, even if one fillets out his recitation of what the child had told him from his opinions, is still of considerable importance in my submission as to the strength of the objections. There then came Mr. Netto's second statement after the Kafkas officer's statement, and that is tab 14 in the core bundle, starts at page 142. And it's clear from paragraph 1 that he'd discussed the evidence filed by both parents and the Kafkas report with the child. And there's then extensive evidence given about the child's reactions. Of course, if it's to be suggested this evidence shouldn't have been given, then perhaps there ought to have been a further Kafkas investigation, a further report from the Kafkas officer as to how things had developed. And, of course, in that witness statement, there are the matters of opinion that are highlighted in the judgment of the trial judge below. I needn't quote those, they're identified and cross-referenced in the judgment. But at paragraphs 11 onwards, for quite some time in Mr. Netto's statement, Mr. Netto explores with the child the father's role in changing his mind. And that goes on for quite a lot of paragraphs. And it's important information, irrespective of any opinion then expressed in relation to it. The purpose is to ascertain the strength of the objection, whether it's parroting, whether it's genuinely held, and whether it's rational. So I've accepted Mr. Netto, of course, isn't a trained welfare officer. He doesn't have that sort of expertise, but other skills and experience brought to bear, and he can be cross-examined as he was about it. His cross-examination was really mainly about his the fact that he hadn't got any training as a Kafkas officer. But a much deeper and more detailed investigation than came from the Kafkas officer. Is it possible that you can have evidence from a solicitor guardian that a judge prefers to that of a Kafkas officer? Certainly, anecdotally, I've seen it happen. The next thing in the history was the pre-trial review that took place on the 11th of May. And you'll recall that it said in the President's practice guidance that indications ought to be given about oral evidence by the pre-trial review. And the pre-trial review order, you'll find, having been made by Mrs. Justice Russell, is in the supplemental bundle at
114.
114, yes, tab 10. And on that first page, you'll see the Guardian inform the court that he may wish to give oral evidence at the final hearing. And then over leaf 1C, Kafkas officer must attend, give oral evidence. D, any further oral evidence a matter for the trial judge to decide. So the substantive hearing then took place, 18th and 19th of May. The position statements are in the core bundle. I'm not going to actually take you through them, but they're there. There are points made about Mr. Netto in the Mother's Council's document at paragraphs 21 to 25 and at paragraphs 38 and 39, but nothing, I think, about opinion evidence. And then we have the hearing with the judge. Questions, firstly the need for Mr. Netto to give evidence, and the whole topic of opinion evidence came up. And there was, as I understand it, quite a debate about opinion evidence, but no debate about the propriety of Mr. Netto giving evidence per se, or about his opinion evidence in relation to the competency matter. Was accepted by the judge. The child did object and had the appropriate age and degree of maturity, but exercising the discretion, he rejected the child's case, questioning the propriety of certain opinion evidence from the solicitor guardian, and in any event preferring the evidence the Kafkas officer, although, as I've already submitted, if you compare the two of them, there's not actually any inconsistency between them. It's just that Mr. Netto's evidence goes further. Having set out that history of how these issues came about, let me address to some extent the laws to the joinder of subject children and the appointment of solicitor guardians and the ambit of the role of solicitor guardians. Because at one time it was extremely unusual for a child to be joined as a party in 1980 Hague Convention cases. And probably the most important move towards a change in that regard resulted from the speech of Baroness Hale in Re D, Authorities, tab 8. Useful perhaps first of all to look at the submissions that were being made on behalf of the child, because the case had been going on for years, both in this country and in Romania. And it was only when the matter came to the House of Lords that an application was made for the child to become a party. And that application was granted, and it was being argued on behalf of the child, on page 102, letter B, that the court below had paid insufficient attention to the views of the child and were wrong not to allow him to be represented. And then 2 paragraphs further on was submitted as to the child objections defence under Article 13, the courts below lost sight of the fact it's a freestanding defence and must be considered properly on the opinion evidence if possible. This is a case where objectively the child's objections were both rational and authentic and did not depend on instinct but on the discernment of a mature child when considering the implications of a return. Then, if I could take you to page 120, paragraph 57.
So sorry,
That's
just
bundled.
going back to 102, I'm just orientating myself. So this was Mr. Howard's
That was
submissions.
Mr. Howard and Mr. Gupta.
That's their submissions.
That was
that's
their
not-
submission, yes. It was submission, not
Yeah.
judgment.
So then turning on to where?
Then page 120, which is part of the speech of Baroness Hale. And I start by reminding the court in paragraph 56, and one can find this in various authorities, that the court's view of the morality of the abductor's actions shouldn't play a part. The court has heard none of the evidence which would enable it to make a moral evaluation of the abductor's actions. They will always have been legally wrong. What you have to focus on is the child. We know that even more recent authorities, such as the Supreme Court in Re E and Re S, one is urged to focus on the child, not necessarily on where we got to the position we are, but the position in which we are from the perspective of the child. And then paragraph 57, there is evidence from both the Kafkas officer who interviewed him, that's the child himself, after the Court of Appeal refused him leave to intervene, and from the solicitor who represents him. Now, if my memory is right, it was the late Anne-Marie Hutchinson who was the solicitor for the child and had provided evidence. And I don't actually have the documents to hand, but I'm pretty sure there would have been opinion evidence in the evidence of Miss Hutchinson. But the view of the solicitor and the Kafkas officer was that the child was adamantly opposed to returning. So the word adamant suggests an opinion being put forward.
Sorry, where's that?
Paragraph 57, the third line.
Oh, sorry, yes, thank you.
And then continuing, paragraph 57, generally, those well-known passages about taking account of the child's views at an appropriate age doesn't mean that they will be decided in accordance with them, but it's important to understand and take account of them because, and I quote now, it's the child more than anyone else who will have to live with what the court decides. Those who do listen to children understand they often have a point of view which is quite distinct from that of the person looking after them. They're quite capable of being moral actors in their own right. That's why I say one can't just assume that because there was influence brought to bear on the child, in this case by the father, that prevents the child having a genuine, strong objection. And then the ladyship refers in paragraph 58 to the Brussels II revised regulation and the requirements about hearing the child. And then paragraph 59 follows children should be heard far more frequently in Hague Convention cases as has been the practice hitherto. The only question is how this should be done. Plainly not good enough to say the abducting parent with whom the child's living can present the child's views. If those views coincide with the views of the abducting parent, the court will either assume they're not authentically the child's own or give them very little independent weight. There has to be some way of independently conveying them. And then paragraph 60 is the three possible ways, which effectively is mirrored now in the latest President's direction. And then in paragraph 61, the ladyship says, hitherto our courts have only allowed separate representation in exceptional circumstances. And the Court of Appeal had recently said it should be even more stringently applied, the rule against permitting joinder. Brussels II revised regulation requires us to look at the question of hearing children's views afresh, rather than the issue coming up at a late stage in the proceedings, as has tended to take place up to now. European cases require the court to address at the outset whether and how the child is to be given the opportunity of being heard. Well, that's what Lady Justice Black was saying in the M. Republic of Ireland case as well. It's what's said in the President's latest practice direction.
Mr. Turner, this was the starting point.
Yeah.
Back in 2007, and since then, as you've taken us to, we've got the guidance and the new rules and so on.
Yeah.
I'm very happy to go through D if it's helpful, but I am conscious that you've got a quarter of an hour left.
Yes.
And I'm sure
Well, I want to come
quite a lot
importantly
more
in a
you want
moment to
get
the present
through.
rules.
Yeah.
But just let me flag up the other cases to which I would have wanted to go into a bit more detail if I'd had the time, which I haven't. But nothing was said in the Ray D case or in the subsequent Ray M case in the House of Lords about the ambit of evidence from a solicitor or the need for a joined child to have a guardian. And it hadn't even been appreciated at that point because the child who was joined did have a solicitor, but there'd been no appointment of that solicitor as a guardian, which would have been required even under the rules as they stood at that time. But that only became appreciated subsequently. And again, Ray M, which is tab 9 in the authorities, House of Lords, much repetition of what's in Ray D and also matters raised as to child's objections and the important considerations. Again, no consideration of the specific points we're concerned with. Then we have the judgment of Mr. Justice Baker, as he was, tab 21 in WF and WJ, BF and RF. Again, I'm not going to take the court to that because we know that His Lordship identified the requirement under the then rules for a child in Hague proceedings who becomes a party to be represented by a guardian. And the pragmatic step was taken in that case of, as it were, retrospectively appointing the child's solicitor as a guardian. The child's solicitor in that case, who became the guardian, was Miss Nina Hansen. And if you go on through Mr. Justice Baker's case, you will find that recited much of what Miss Hansen had said in the evidence she gave to the court, said or written in the evidence she gave to the court, and there was quite clearly significant opinion evidence. So I could flag up for you, but you'll find it quite easily. I think it's probably in our skeleton argument, the paragraphs in it, but there is a great deal of opinion evidence, no criticism of that whatsoever. Let me look then at the rules that have replaced the rules that Mr. Justice Baker was looking at. Although they've replaced Mr. Justice Baker's rules, they've not changed them in any significant effect. And first of all, we have, and these are the family procedure rules, Rule 16.2. That's in the authorities bundle at part 4, tab 4, sorry, page 17. When the court may make a child a party to the proceedings. The court may make a child a party to the proceedings if it considers it's in the best interest of the child to do so. And then there are various situations where that rule doesn't apply, but it does apply here. And then there's a note that says the practice direction 16A sets out the matters which the court will take into consideration before making a child a party under this rule. And that's what I had in mind when my Lord or Justice McFarlane was asking me what the criteria are for making a child a party. And we've got this direction 16A, so we'll come to that in a moment. So if it considers it's in the best interest, so that was the test that the Deputy High Court Judge was applying at the first hearing in this case when the child was joined and Mr. Netto was appointed guardian. Then I take you to 16.4, which is the next relevant rule. And that's the one that says effectively that children in the sort of proceedings we're concerned with must have a guardian. So they're proceedings that are not specified proceedings or proceedings to which Part 14 applies. And then Rule 16.6 in our bundle at page 24. We're not concerned with, because it doesn't specify Hague Convention proceedings. And then 16.22, which is page 42 in our authorities bundle.
Sorry,
16.22. This is chapter 7 of the family procedure rules. This chapter applies where the court must appoint a children's guardian under rule 16.4. So we've had the child joined under 16.2, has to have a guardian under 16.4, and then we turn to 16.22 that says this chapter, so the whole of the rest of the chapter applies. 16.24 and there is listed who can be a children's guardian in a Hague Convention case, because it's part of chapter 7 which applies to joinders under 16.4. And you can see there are a number of options. The court may make an order appointing as a children's guardian an officer of the service, and that's CAFCAS, because we know it's defined elsewhere as, or a Welsh family proceedings officer, or if the person to be appointed consents. So CAFCAS don't have to consent, but if it's not going to be a CAFCAS officer, a person other than the official solicitor or the official solicitor. So, in effect, anyone can be appointed. There's no priority given there in 16.241, although we'll look in a moment at the practice direction. But there's nothing to stop us in this case having a children's guardian and a direction for a CAFCAS report, which is something that not infrequently happens and was what happened in this case. (16.424) paragraph 2, an order appointing a children's guardian may be made by the court of its own initiative or on the application of a person who wishes to be a children's guardian or a party to the proceedings. And that was what happened here. Sub-rule 4, an application for an order appointing a children's guardian must be supported by evidence. Well, that's exactly what happened here. Mr. Netto put in evidence. And then sub-rule 5, the court may not appoint a children's guardian under this rule unless it's satisfied that the person A can fairly and competently conduct the proceedings on behalf of a child, and B has no interest adverse to that of the child. So although I said that under sub-rule 1 effectively anyone can be appointed, it's only anyone who satisfies those criteria. So the court does have to be satisfied that it's an appropriate person. Equally, a CAFCAS officer can be appointed a guardian and instruct a solicitor themselves, which is another thing that happens in Hague Convention proceedings. But you have the problem that arises if the child doesn't agree with the guardian's views in that situation. You have that in other forms of children law, I know, in public law, children law. Then page 48 in our bundle, which is rule 16.27, is the powers and duties of a children's guardian. Powers and duties are set out in practice direction 16A, must be exercised in accordance with the practice direction 16A. So let's look at practice directions 16A, which is page 66 in our bundle. And the relevant part starts in paragraph 7.1. Appointment of a children's guardian under rule 16.4. When a child should be made a party to proceedings. And on the next page in the bundle, there are, in subparagraphs lettered A to J, the sort of situations which may justify the making of an order for joinder. Doesn't purport to be prescriptive or comprehensive, but they are the sort of situations where it may be justified. And then 7.4 of paragraph 7.4 of that practice direction. When a child is made a party and the children's guardian is to be appointed, consideration should first be given to appointing an officer of the service. So although the rule itself says nothing about priority, the practice direction does. But having just a Kafkas report may limit the information available. But here, the fact was, the direction was for Mr. Neto to be a solicitor guardian and to provide evidence and for a Kafkas report, but not Kafkas as a guardian. And then duties of the children's guardian, 7.6. Fairly and competently to conduct proceedings on behalf of the child. And then a children's guardian who is an officer of Kafkas has further duties. And you can find some of those at page 68 as well. But I suggest there's nothing really material in that for the purposes of our case. It's things like appointing a solicitor unless one has already been appointed.
So there's nothing in this about the evidential role of a guardian?
Nothing at all. And that's the problem. There's nothing anywhere about the evidential role, although one finds in the case of LC in the Supreme Court, which is tab 10 of the authorities.
Isn't that more just by way of passing reference or
Well,
observation?
passing reference or not, it's a reference.
Okay, yeah.
Um,
Which tab?
10.
Tab 10
Thank you.
starts at page 153. And I think it's paragraph 44 onwards. So paragraph 44 is where Lord Wilson deals with this. And approves what Mr. Justice Baker had said in that earlier case. Paragraph 53, paragraph 7.2 of the practice direction offers non-prescriptive guidance about the circumstances that may justify grant to a child of party status. And in the particular case that the court was concerned with there, one sees at the end of paragraph 53, the example most apt to the present case is where the child has a standpoint incapable of being represented by any of the adult parties. And at paragraph 54, His Lordship spoke about the sort of evidence that neither party could give about the child. And then importantly, paragraph 55. Grant of party status, the child leaves the court with a wide discretion to determine the extent of the role which she should play in the proceedings. Although unusually in convention proceedings, Mr. Justice Cobb heard oral evidence from the parties as well as from Ms. Vivian, the Kafkas officer. It would surely have been inappropriate for him to receive oral evidence in court from the child. Of course, the best way is perhaps have the child give evidence, because children can give evidence, and then the court can judge for itself. But of course, a judge isn't an expert any more than Mr. Netto is an expert, but it has expertise, just as Mr. Netto has expertise. In all probability, however, the reasonable course would have been to confine T's participation in the proceedings to 1, the adduction of a witness statement by her, or of a report by her guardian, which was focused on her account of her residence in Spain, including of her state of mind at the time. 2, her advocate's cross-examination of the and 3, her advocate's closing submissions. It doesn't directly cover the question of whether there may be oral evidence, but it certainly envisages a report being provided by the solicitor guardian. And what we do know is that when the case was remitted for rehearing, it was heard by Mr. Justice Roderick Wood. There was evidence from the solicitor guardian, and it included opinion evidence. But again, none of these cases was challenged, so it's evidence of what happened, as it were, rather than whether it's right and proper. And then, of course,
except your point is that Lord Wilson, in referring to a report, including state of mind and everything else, might suggest he had in mind what might be described as opinion evidence.
Quite. And that's certainly what happened, as we see from Mr. Justice Roderick Wood's subsequent. Then there was the Mrs. Justice Theis judgment, which was formed the subject of a conjoined appeal. No
Mr.
complaint
Turner,
made at the time in that.
You're now trespassing into
May
Mr.
I have
Green's
5 minutes, please?
You need to speak to Mr. Green, not to us.
I can take it off my my reply time if necessary,
Certainly, of
if we're
course.
running short.
I know you've got a great deal to say, but it's important that we're fair to all parties.
I'm sort of laying the ground, though, as it were, which others may benefit from. The Ciccone decision by Mr. Justice MacDonald,
Yes.
tab 22, I do invite the court to look at all of the relevant passages in that case, because his lordship didn't purport to make a concluded determination about the propriety of anything. It was just his preliminary view. I'm not going to take you to it.
Well, he didn't say it was not admissible.
No, he didn't say it wasn't admissible. No.
He was just saying it might cause difficulties.
Yes. Yeah. People have said, or submissions have been made about problems being caused by privilege. We don't accept that there are any problems caused by privilege as long as the solicitor guardian checks with his client as to what may be disclosed, and the fact that he's going to disclose what the child has said.
Well, it's inevitable, because the statement comes from the solicitor. The solicitor is going to disclose what might otherwise be privileged information. I mean, it's
Yeah. But insofar as the solicitor sets out opinion evidence, the solicitor is simply doing his duty by doing the best for the child, which he's required to do under that rule we just looked at, and he can tell the child that this is what I shall be doing. And if you don't like that, sack me. But there is a potential benefit anyway if the Kafkas report is contentious or inadequate, although the trouble is if you only have a Kafkas report, you don't know if it's going to be inadequate. But we do say here, just looking at the factual material in Mr. Netto's statement, that it did add value. Now, 2 final points as to whether evidence, opinion evidence, can be given by a solicitor guardian. We draw attention, first of all, to Section 3 of the Civil Evidence Act of 1972. That is in our authorities bundle.
Tab 2.
At page 12. Tab 2, page 12. A admissibility of expert opinion and expressions of non-expert opinion. So subsection 1, subject to any rules of court made in pursuance of this Act, where a person is called as a witness in any civil proceedings, and Mr. Netto was a witness, he was directed to file a witness statement, his opinion on any relevant matter on which he's qualified to give expert evidence shall be admissible in evidence. Well, that raises, well, is expertise sufficient, or did he go beyond his expertise? Because under that rule, he'd be permitted to give evidence in accordance with his expertise by way of opinion. But quite apart from that, just bear with me a moment.
I thought you were referring to subsection 2.
I am going to subsection 2, but I'm starting with subsection 1. Subsection 2, a person who's called as a witness in civil proceedings, Mr. Netto, a statement of opinion, where a person is called as a statement of opinion by him on any relevant matter on which he's not qualified to give expert evidence, if made as a way of conveying relevant facts personally perceived by him, is admissible as evidence of what he perceived. And that's where I really hang my hat.
Well, it's a bit tricky to get in under 1, given Part 25 and all the rules about experts.
Yes, although I'm not sure, and I should have checked, and I haven't, whether Part 25 is made in pursuance of the 1972 Act. But I do go then finally to Section 13 of the Children and Families Act, which is tab 3, page 13, control of expert evidence and of assessments in children proceedings. A person may not, without the permission of the court, instruct a person to provide expert evidence for use in children proceedings. Well, we know, I can take you to it if you like, but Hague proceedings are children proceedings. It's defined in the rules. Is opinion evidence necessarily expert evidence?
I don't think that's geared towards a guardian.
No.
I wouldn't have thought, is it?
Sorry, my lord.
Not geared towards the role of a guardian.
I
This provision.
don't think it is. But the trouble is, no great thought has been given to tying all these threads together ever, and that's why the court keeps suggesting that the Rules Committee look at it, and the Rules Committee didn't after Mr. Justice Baker's decision. It didn't after LC. Perhaps it will now. But that rule doesn't apply to a CAFCAS officer, and we can find that on page 14 at subsection 8C. As far as the rest of my submissions are concerned, may I simply adopt what's said in Mr. Harrison and Mr. Bennett's careful skeleton argument. And finally, we look at the judgment itself. I'm looking at what's paragraph 54. It begins, he said it's important to be strict. I don't know if that's paragraph
52.
53, yeah.
It's 52 in the original.
He said it's important to be strict about the difference of giving wishes and feelings and giving opinion. This is Mr. Netto, if he proceeded to give his opinion. His over-exuberance was evident in the description of the child being caught between the parents like a ribbon. He said it was one of the most striking things a young person has ever said to me. Well, isn't that fact? It's not opinion, is it? He was taken through passages of this statement, put him directly, he'd overstepped the mark. Looking at this issue, the court can place very little weight on Mr. Netto's opinion evidence, even if it's admissible, about which this court has considerable doubts. Well, first of all, I submit solicitor guardian can give evidence, and in this case was directed to give evidence. Secondly, I submit that that evidence can properly include opinion evidence, albeit it's to be careful not to trespass into matters about which one would require, for example, medical or psychological expertise of some sort, but bearing always in mind that the witness is susceptible to be cross-examined about it. Because if one doesn't, then you run the risk, as here, with the Kafkas officer's evidence not being as full and complete as Mr. Netto's material that was provided. We do say that that was discounted, and therefore the voice of the child in this case was stultified, because the judge was diverted by those issues of the giving of evidence and in particular the giving of opinion evidence by Mr. Netto, and the significance of the father attempting to influence the child. He failed to look at it in the round. So, and it then has to be remembered that, of course, if there's no return subsequently, then of course there can still be a full welfare hearing in this country. That's not necessarily the end of the road, but we say that properly there should be a rehearing of this case, so all of these matters can be properly investigated with the ground rules set out clearly beforehand, so everyone knows exactly what areas can be covered by whom and what's going to be admissible. Those are my submissions, and I'm grateful for the extra time.
Thank you very much, Mr. Turner. Yes, Mr. Green.
Thank you, my lady. And as you know, my lady, I attend today assisted by Miss Ishmael, who sits behind me, but I've been assisted in the preparation of my skeleton argument by Professor George.
Yes.
And my lady can find that at tab 9, page 70 of the core bundle. My lady, I accept, as did Mr. Turner at the outset, that the father's, my client's conduct has been criticised. And like Mr. Turner, I say to my lady that that should not deflect from the points in issue in this appeal. And my lady will know that our role is supportive of the child's position. And it's on that basis that I endorse all that has been said and that has been written. But what I set out in our skeleton argument is some additional points which we would seek to raise. And the first focus at paragraph 5 is really
Paragraph 5?
Paragraph 5, my lady.
Yes, I have it, thank you.
And that's the procedural circumstances in which the issue at hand of a solicitor guardian giving opinion evidence came to be considered. Because it is not, because it was raised on the mother's behalf at the hearing. And that much is clear from my learned friend, Mr. Edwards' skeleton argument. As Mr. Turner has said, and the references in Mr. Edwards' skeleton argument at paragraphs 21 and 25, or 21 to 25. His challenge was focused on the fact of joinder.
Sorry, challenge on?
On the fact of joinder.
Oh.
We say at paragraph 7 of our skeleton argument that Mr. Edwards in any event was not entitled to make that challenge because
There'd be no appeal.
there'd be no appeal, and that's the most important, of course, my lady. I say also it was fully argued, experienced counsel. You have those points then at paragraph 7. My lady, it's important to note that there was no focus then at that stage on the way in which Mr. Netto had performed his role. And it's also fair to point out that Mr. Edwards did not rely on the Ciccone and Ritchie case in his skeleton argument. He did not seek for Mr. Netto to give evidence, and there is nothing in his skeleton as to this principle of the solicitor guardian and opinion evidence. And that is not a criticism, because Mr. Edwards would be as familiar as anyone else in this field with the way in which Mr. Netto had fulfilled his role. As Mr. Turner has said, this has become, rightly or wrongly, a commonplace way of dealing with matters. And so he would have been familiar with the way that Mr. Netto had spoken to the child and then given his views on the authenticity or not of that child's views. The next question, in a procedural sense, is how and when did this issue arise? It is clear by agreement that it was only during the course of the hearing. The judge, and I don't need my lady to go, but I can give you the quote from the judgment at paragraph 53, page 105. The judge said, "It is important to note that there was no root and branch objection to Mr. Netto's opinion evidence before it was sought for him to give evidence or to go into the witness box." So we have that clue. And the judge says at paragraph 42, page 101, this was Mr. Turner started his submissions with this quote. He said, in his two statements, Mr. Netto provided two distinct types of view. Firstly, the views of the child. Secondly, Mr. Netto's own views about the views of the child. It is accepted that the first category was completely admissible. It is the second category that the mother objects to. And then the judge says, I introduced the topic with my assessment of Mr. Netto. So I'm not clear from that when it was that the judge introduced that topic, but it does seem to have been judge-led rather than anything that was submitted by counsel.
So you said previously, but you said in your skeleton, that there was no application for Mr. Netto to give oral evidence, but yet he ended up doing so. So there was no application before the hearing. So was it? Do you know whether an application was made during the? Must have some application or something happened during the hearing, which then led to that happening.
Well, my lord knows that it was trailered at the pre-trial review that Mr. Netto had indicated that he might wish to give evidence.
Yes.
Whether or not there was a formal application, as I understand it, there was discussion about whether it was right that he should give evidence because the judge discusses it in his judgment.
Right, and he. Yeah, okay.
I can take my lord to that if it's helpful now.
No, that's all right.
What we say about this procedural route is that the fact that Mr. Netto is then subjected to significant criticism, it's important really from a fairness perspective. Because is it fair, we ask, that this issue about the propriety of his approach is raised for the first time while he's giving evidence? Is it fair that he was not warned that there was going to be this exploration of the extent of the role that he'd been asked to perform? Is it fair when there was the possibility, he should have been warned, of significant adverse findings being made? And I make that submission in the context of the REW care proceedings, non-party appeal case, the reference to which is in my skeleton argument at the bottom of page 6, paragraph 9. In which, and it's not a particularly controversial submission, that a party should know the case to which they are being asked to answer. And my submission is that it was further unfair that that issue was raised when, as has been established, as Mr. Turner has told you, this was common ground, the way in which the solicitor advocate role was fulfilled. When Mr. Netter was asked, or challenged, as I understand it, that his statements were full of his opinions, Mr. Netter replied, frankly, yes, I accept that. It is how solicitors who do this practice work. And even, my lady, if guidance needs to be given as to how that role is to be performed, at least we understand that Mr. Netter was attempting to assist the court in exactly the same way as he'd done many times before, and in fact had been thanked and warmly congratulated for so doing. It's important because the parties were not given the proper opportunity to deal with the issue before it was raised. And in an obvious example, had they been given the opportunity, then they would have been able to take the judge to some of the many authorities which this court has been taken to. They were taken by my learned friend Mr. Bennett to the C and M and X case, as we know, but they weren't, the court was not taken to the many other authorities in which it is shown that a solicitor guardian can express views and be accepted to so do. We say that there should at least have been consideration of the issue further by way of written submission.
But that presumably wasn't an application that was made during the hearing.
My Lord, no. As I understand it, there was not the opportunity to do so. The issue was taken up by the judge while Mr. Netter was giving evidence. In any event, the point is that it didn't happen and there was no opportunity properly to prepare. My Lord, the consequences, my lady, the consequences of the way in which procedurally this arrived, I set out at paragraph 10 of the skeleton argument. Obviously at 10.1, the core of the appeal is and the focus is that no weight was attached to his evidence. Further, that Mr. Netter was subjected to criticism for his performances of his role without adequate opportunity to answer those criticisms. And thirdly, it was based on limited argument in circumstances where the parties were given very little opportunity to prepare to deal with the issue. My lady, there were also issues insofar as the preparation of the case is concerned that arose. And I address those, my lady, at paragraph 11. If the Kafkas officer was to understand that Mr. Netto's evidence was going to be set aside or disregarded in the way that it was, we ask, to what extent might she have undertaken her inquiries differently? Not only that, by the time that Mr. Netto gave evidence, there wasn't an opportunity for her to be asked about that in evidence. And the second option might have been, given that an important part of the appellant's case is that the child's views developed over the course of the proceedings, wasn't it right that a further report should have been sought from Kafkas as to how those views had developed? And as a result, it's right, and we support the appellant when he says that the views of the child were stifled or neutered. My lady, we spend some time in the skeleton argument looking at the role of the solicitor guardian and the rules. My friend Mr. Turner has dealt with that to a great extent. Can I take my lady to paragraph 24?
Thank you.
In which, my lady, have that. We really look at the results of having disregarded the evidence of Mr. Netto. disregarded, as I was just submitting, the development of James's view, of Dee's views. And it was not in any dispute that Mr. Netto had spent significantly more time with the child and that he'd been in communication with him in a number of different ways. And it was not in dispute that he'd met him more recently than Kafkas officer. And all of those factors, we say, point to the court giving significant weight to Mr. Netto's evidence. But not only that, it saw the judge failing to take into account, as Mr. Turner put it, when you strip out the opinion evidence, you're left with factual evidence, much of which was ignored by the judge and importantly could have informed the authenticity point on a factual basis. And my lady will read closely the evidence of Mr. Netto, but within that, the factual recording of the balance of the child's views and the way in which he had good things to say about each of the countries was essentially set aside by the judge, which was not right. My lady, insofar as ground 2 is concerned, which we address at paragraph 26 and 27, we fall in behind the appellant's position insofar as the judges erred in attaching little weight to the competent child's views. What I would just want to emphasise lastly is in relation to ground 3.
If you go to paragraph 27 of your skeleton,
Yes.
you align yourself with the submission made on behalf of the child, relying on what was Mr. Justice Mostyn said in ASCPW about, in effect, the weight that should be given to a Gaelic competent child. How does that fit with what Baroness Hale said in Re-M?
I accept, my lord, that the submission has to be seen in that context, because it logically developing the point means that if in a case where child objections are raised as an exception, there has to be a limit to the extent that those objections are and the authenticity of those objections are followed. So one has to see this through the prism of what Lady Justice Hale says in that.
Well, it seems to conflict with what she shows about the very broad considerations that the court has to take into account. So I'm just speaking for myself. I find it rather difficult to fit that within the Hague analysis.
My lord, I have to accept that what Lady Justice Hale says in Re-M conflicts with Lord Justice Mostyn's views.
Well, he says if it's effectively, he says if it's a Gaelic competent child, it's determinative.
There has to be a limit to that. I accept.
So you don't rely absolutely on, you're not asking this court to adopt or try and shoehorn Mr. Justice Mostyn's view into Re-M.
Well, my lady can take Mr. Justice Mostyn's views as expressed in that case, his guidance as to when a child is Gaelic competent and of the age that the child was in this case, then one could be guided by those comments. But what Lady Justice Hale says in Re-M has to be where this court finds itself.
Thank you.
My lady, the last ground, which focuses on the welfare concerns, welfare risks, and the submission, overarching submission, is that the judge failed to take into account wider welfare issues. And as well as endorsing what is said on behalf of the appellant, insofar as failing to take into account those wider welfare considerations, we set out in some detail those matters which, importantly, were all before the trial judge and are not even mentioned in his judgment. In particular, the status of the child upon return.
So the reality is, if the appeal is dismissed, the order will be for the child to return to the second country,
Yes.
not the first country, not the
Yes.
child from, not the country from which the child was abducted.
That, on the evidence that's been made available as a result of the order of Mrs. Justice Russell, is that there is no immigration status for the child.
But as I understand it, that the mother is not currently living in the country from which the child was abducted.
That is right. And just so procedurally, my lady has the point. This was raised as an issue before Mrs. Justice Russell,
Yes.
the mother having said that, or inferred that she did have immigration status, was required to file evidence in support of that contention, at which point it was discovered that she was no longer resident in the country in question. The basis upon which she says that she would have the right to live there is on the basis of the child having a student visa there.
Yes, understood.
That
Yes,
is
sorry
also...
to cut across you, but your application for permission to appeal in respect of that issue was refused.
That is right, Madam.
So,
Nonetheless, we say that it feeds into the wider welfare considerations when considering discretion. My lady has those points that are made in the skeleton argument insofar as the discretion is concerned. Is there anything else that, my lady, I can assist with?
No, thank you very much indeed. Yes, Mr. Gresham.
My ladies and my lord, thank you. In the relatively short time we have before lunch, I'm going to make, if I may, just a few introductory points.
Certainly.
The first is to try and set this dispute a little further into context. It's recognised by everyone and is clear from the documents that the child here was retained during a period of holiday, and that holiday was ordered by the courts in Singapore on the father's application. That is not the whole of the picture, and one can see, if you'll turn please, but only briefly, to page 503 in the supplementary bundle. A summary prepared by the mother of the application that the father made that led to this holiday being granted in November of 2022. So I hope what you have there is page 43 of a chronology with an entry of the 18th of November 2022. And on the right is a summary of what the father was seeking by the application that he made on that. Including, of course, for the child to attend school in this country, to reside here, qualify as a home student, to undergo counselling here paid for by the mother, his application for sole custody and care and control, the court in Singapore to recognise and accept the inherent jurisdiction of the English court to make decisions in the best interests of the child when agreement couldn't be reached, and for the judge that the father had taken issue with because of their decisions previously to be excluded from presiding over any further matters in relation to the child. It was at the hearing on that application on the 13th of December that the holiday that the child took here, and during the course of which he was retained, was granted on the express basis, as is clear, that he would travel here on the 17th and return on the 6th of January, and of course we know, and it's accepted, that during the course of that trip he was retained. This is referred to within the judgment, but following the child's retention here, he had no contact with his mother at all from early January until contact was restored by the order of Ms. Justice Russell on the 11th of May, a period of 5 months. That position continued, notwithstanding the encouragement that was given by the Deputy High Court Judge on the 22nd of February, which can be seen within his order at page 110 of the supplementary bundle, paragraph 7. The court having indicated then that it expected regular contact to take place between the child and the mother, at the least by way of text messages at least twice per week. In the run-up to the father's application in November of 2022, and indeed for a considerable period before then, he had been sending to the child messages that were intended, and clearly intended, to pressurise him into leaving Singapore in the care of his mother and into coming to England to live with his father. That was a sustained and egregious course of conduct that it is obvious, in our respectful submission, the child found deeply distressing and upsetting. The judge sets out within his judgment some of those messages at page 20, paragraph 60 onwards, under the broad heading of authenticity. The messages in the immediate run-up to the father's application start, as recounted by the judge, at paragraph 62. I'm sorry, I'm using the approved note, so my paragraphs might be different to yours. But paragraph 62 begins, on 24 September, the child said that. It is at the foot of the series of bullet points showing messages up to the 22nd of September.
Sorry, what date? What?
24 September 2022, these messages are from. In this particular paragraph. The earlier bullet points show messages from earlier in time.
Okay.
20th, Charles said he'd just got his phone back. Is that where we're looking?
We have a paragraph 85.
It's 85.
80.
Yes, we have
That's
that.
somewhat further out than the paragraph.
No, it's because they've all been given bullet points and we approved.
They've been given numbers as
I
opposed
see.
to bullet points, but that's fine. We know where you are.
Thank you. So these are the messages that immediately precede the father's application of November, and they show the child expressing his concern and upset that the father had taken steps to deprive him of access to various electronic devices. And it's completely apparent from those messages that the father had done that in order to try and cause the child to say that he wanted to move to live in England. And the child's access again to his devices, being deprived of which, having left him so upset that he tells his father he's panicking and hyperventilating and he doesn't know what to do, is effectively made conditional upon the child coming here. There are a great deal more of those messages that are set out in the bundle, and equally set out in the bundle are the child's references to his distress at receiving them. The judge sets them out for an obvious purpose, to show and to justify the judge's eventual conclusion that this was a child that was placed under very considerable pressure. The reason that I'm referring to them now, and at this introductory stage, is because in our submission they start the series of missteps that led to the difficulty that has now arisen within these proceedings. Because, of course, just as all of these messages, the father's applications and what he had obviously sought, including through putting considerable pressure on this child to achieve, form the background of the judge's decision, they also form the background of how the child was brought into these proceedings by being directed by his father to the doors of the child's solicitor, having been told by the father that that solicitor can help him get what he wants. And so, when the child goes to see Mr. Netto and has meetings with him, this is what the child has experienced. But of course, because of the stage at which that was done, and because of the position as a matter of evidence when the application for the child to be joined came before the court, none of that was really known to Mr. Netto, and none of it was apparent to the judge. So I will come, probably now after lunch, to paragraph 9 of our skeleton argument, where we set out in summary form, and I will only address them in summary form after lunch, the procedural difficulties that followed on from that, the child effectively having been joined, a best interest decision, of course, that being the sole test, whether it's in the child's best interest to be joined as a party through his own solicitor in circumstances where he had been subject to the most appalling pressure, but none of that was known to the solicitor that he was seeing or to the judge when those decisions were taken.
But we're not rehearsing whether it was right for the child to be joined, because there's no appeal in that room.
No, of course not.
It's the consequences.
Indeed.
Thank you. Very well, Mr. Gresham. That helps set the scene. Thank you very much. At 2 o'clock, please.
Court, right, in